Hey there, Truster fans. Welcome back to our intellectual salon. This is part two of our conversation with Brendan Guildea. Hopefully, you caught part one. If not, here's a link to it. In that, we've focused mostly on digital rights management in the age of NFTs and metaverse and how all that will affect our lives in the brand new token economy. And in part two, we're going to talk about the new crowdfunding laws for the European Union and focus somewhat on family law, which is Brendan's specialty. So it was a blast, and I hope it will be a blast to you. Enjoy. But yeah, we can start part two because we barely touched the subject of intellectual property in the age of all kinds of digital exercises by all kinds of different people with a whole bunch of different purposes. And I just, after our conversation, I've reviewed some of the materials that I've saved when I was preparing for the interview, and it just really struck me as something. I don't think there is a messy, other than international politics, I don't think there's a messier space than intellectual property when it comes to digital rights management. I've I tried soaking up so much material from different sources, and we've already discussed that so many people are putting out a lot of material in their legal blogs, something that we haven't seen 20 years ago. A lot of people are offering up their services via those channels. So that's something that creates a lot of confusion because we've gone through that in the mid 90s with medical blogs. I don't know if you remember that or not. In 1996, 97, or like medical.com, medicaldoctor.com, americanmd.com, all those blogs popped up with all kinds of medical advice. So something that hadn't happened before then, and a lot of people really got on that, and just the wars, the all kinds of conflicts over the specifics of a particular medical advice. I mean, can you imagine that going on online? It's like when I'm a doctor and I'm giving out medical advice online, and I have to sign all kinds of legal stuff before I log on, so that that doctor that gives out legal medical advice online is not liable for any.
Yeah, liability. I can jump straight in there. So I did a year working for a practical law company, I think, which has since been bought out by Thomson Reuters. But they described, in terms of legal materials, as a kind of a pyramid. So in the bottom layer, the big thing in the 90s was, can the law, the legislation be put on the internet? And that was, everyone was very excited. Wow, I don't have to carry, the books of acts to court. If I have a laptop, I can view them on there and keep them up to date. So that was the new thing. And then what's called kind of the middle layer of the triangle was called secondary material. So you might have someone making general comments on a legal development. And then higher up, you have like the top of the pyramid, which is like bespoke comment on a very, very specific set of facts. Okay. And the difficulty with medical advice is a great kind of analogy, but also legal, is that if you're a legal publisher and you're holding this information out as being reliable, and if people rely on it, then there's a problem. If they injure themselves, or particularly in the legal sector, if they rely on it, it turns out the regulator or the police are knocking on their door saying what you're doing is not only illegal but maybe a criminal thing. So we do have that. So, and I think what we mentioned last time was kind of like the oh, look how clever we are. If you want the bespoke advice, kind of come to us. And then almost the cynical exercise is, can you create this kind of mutual dependence on the source of your knowledge, really? So we're all reliant on our local doctor, if it's a GP, to some extent. But obviously we can use the tools, the online tools, insofar as they go, but we wouldn't... Are you there? 1 2 1 2.
Oh yeah.
We wouldn't. You wouldn't make any massive life choices on the basis of what you'd read on a blog, hopefully. But that's kind of, we're into conspiracy theories and so on. Then.
No, one thing that's really important, I think, to realize is that well, not realize. I mean, we both understand perfectly what's going on, but it's when you're giving out financial advice, I'm sure you're familiar with all kinds of disclaimers that we have to put out there before we're actually able to put something online that suggests to people or recommends stuff. I mean, that's just
Absolutely.
it's borderline crazy.
Absolutely.
So
And that's, let's say, in, let's say, part one of our conversation, we've been talking thematically, kind of all, and as your intellectual saloon, meandering through those. So what I would like, and I don't know if it's something your listeners would appreciate, but what we can do in this particular this part is look at the EU regulation of crowdfunding.
absolutely,
Because
absolutely.
like said, so I have a graphic, if you can see on the screen here. I'm looking at the European Union crowdfunding regulations. And really what this sets up is a structural framework for what was happening anyway. So on the top right, we have a platform that is purporting to be kind of an intermediary, a neutral intermediary, for the bottom, which is a company seeking to raise capital, probably an SME or maybe a larger company for a specific project. And then top left, then we have the investor. And kind of generally what we're seeing is kind of, the small investors or the unsophisticated investors. And when you add them all up, you can easily raise the 5 million euro cap. So you can, for any particular project, you cannot raise more than 5 million euro under the Act. So all of these three kind of engage in a kind of a dance, and all trying to maybe advantage play each other. But in the middle, then we have this kind of regulator, and I put in brackets plural, because if you're a crowdfunding platform and you're providing, as your service in multiple jurisdictions, up until the regulation in Europe anyway, you might have 3 or 4 different regulators. So what this regulation then tries to do is it tries to kind of, what the EU's mission has been over the last 20, 30 years, has to kind of unify it, the system or the ecosystem, and to kind of insert, hopefully kind of accurate definitions of what is happening. And it's just because you mentioned earlier the idea that, when does information become advice? Okay. And certainly in relation to the crowdfunding platform, that's what you want to avoid. If your kind of readers look at the first recital to the regulations, so the recitals and regulations are kind of, they're not non-binding, but they kind of give context for the regulation. So when a case comes to court, the judge really needs to consider, what is this piece of law trying to achieve and in what context? So for the crowdfunding platform, first of all, it's saying that you can register as a platform, and then each country will have to maintain a register of such platforms as service providers. But that does not equate to, or that does not automatically give such a platform the status of a credit institution. Okay, so that's really important, that they need to register separately if they are, let's say, offering whatever it is, and people give them the money, as opposed to being the signpost for, okay, click on this link, we'll direct you to where your money can go. And then they might have a separate kind of fee structure with the client. Secondly, then they will also have to register with as a payments institution, so to do payments under the payments regulation. So they'll need to. So it's almost like a crowdfunding platform might have to wear 3 hats. And that's, excluding your general insurance and your GDPR obligations and whatever corporate requirements are in the jurisdiction. But the key point in the first recital of the regulation is this aspiration that the crowdfunding platforms are trying to do what they do without taking on risk. That's the first thing that it says. But then if you kind of read the rest of the regulation, and it runs to some 66 pages in the English version anyway, you kind of see an erosion of that. Well, they have to do this, so they can't do that. And also this kind of concept that they need to be able to provide information, but the crowdfunding platforms need to wake up and say, as soon as you hold someone out or, push a particular offering, well, then maybe it is advice. But so the regulation, it can't foresee what trends will emerge. But what it does is it says, okay, if you have a filtering let's say, search function on the platform, such as I'm looking for investments under a certain amount, or maybe for a specific product type, that filtering in and of itself doesn't amount to advice. And I think that gives them a little bit, a modicum of certainty that this is the functionality these platforms can have.
Can I ask you something? A quick
Yeah.
question. Does it depend in any way on the actual medium of the crowdfunding campaign, whether it's done in euros or pounds or cryptocurrency or any other means to raise funds?
I honestly don't know. I wouldn't think so. But I don't even think that's covered in the regulation. I might be wrong, but my assumption would be that any payment is fine, so long as there's an element of, anti-money laundering. So when we move down to the company in and of itself, the company in and of itself then has the obligation to do the KYC, know your customer, know where the money's coming from, and hopefully, if you are getting Bitcoin, maybe have some kind of secondary way of confirming the identity of the person who's buying it and from where they're getting the resources. So that's kind of an excellent question, and that is built into this regulation, those types of concerns. So we have then the advantage again in the aspiration that the EU is kind of the federation of the EU, kind of hopefully having no borders for the companies. And we come across this word arbitrage, and sometimes we have, kind of giving, let's say, the eclectic nature of the English language, we have some words that kind of are half translated into English from other languages. So arbitrage to me seemed, it just jumped out at me. I think its first mention is in Recital 9. What is arbitrage? And I'd encourage your users to maybe just Google it, or in their own language try and find the word and Google it, because there's an element of, there's 3 or 4 meanings that I could find in researching for this talk, and one of them is highly ironic, because arbitrage in kind of, let's say, the commercial buying and selling market means a practice where you buy and sell the same thing more than once. And which obviously shouldn't be permitted, but it's used in the context of the regulation. I don't think without that kind of awareness of that background, to say that they don't want companies, like the blue down the bottom, they don't want companies to get tied up if they're, let's say, based in France and they have an office in Germany and they provide the service, let's say, in a third country, in Italy. They don't want them getting tied up in red tape. That's the one thing. But then on the other hand, you don't want companies kind of shopping around the EU for the most lenient regulator. Okay, so in that sense, regulatory arbitrage is kind of this idea that there's a minimum standard in Europe, and there should be no allowance for, in relation to your question, this, there should be one approach to what currency or where the money is coming from, or other proofs like that. Okay, the minimum requirements, and again as well, the European Central Bank has even had a kind of a talk on, well, what does the word arbitrage mean? I have an inkling that it is a word maybe in French that doesn't quite translate very easily into this particular regulation, because I think there's massive room for doubt. And then if we just go over to the left then, and I'm happy to kind of go back then into the normal talk approach for this interview, but the idea then of the investor, and I would have come across kind of the long tail of investors, so not, let's say, the big 10 or even the first 100, let's say, money makers or market makers in a particular sector. We're talking about the accumulation of everybody else. So the retired, the retired banker who's investing in his spare time, and the young teacher maybe who might have a few quid and might be trying to increase their own savings in a way, maybe to buy a house or something. So this investor is envisaged primarily in the regulation as a small person, as an individual or a natural person.
Well, that's actually something that I wanted to focus on, because what we do at Trustra is we mostly, well, Yeah, we mostly cater to that particular type of person, an investor that you just described, someone who's or a small business that's crypto heavy, or people are involved in, I don't know, whatever activities online that are that underlined by the necessity for crypto, whatever, I don't know, gambling, recreational or day trading, whatever. So that's basically our clientele. And I wanted to ask you, like, for example, myself, I was never able to become an investor because the majority of my life I was working paycheck to paycheck. So that's not the kind of financial standing that allows you to actively invest. And I was wondering if you have like an angle for me to maybe, I don't mean to say to recommend a course of action for a person like that, but maybe like give some sort of an overview of what's going on with investments right now. So maybe people like myself that are just putting away, I don't know, a couple of hundred, or just don't know how to get started and how to crowdfund if they're a small business, maybe how to get it off the ground. Do you know what I mean? Is it too messy a question, or?
No. I mean, and that's why I have the visual, because there are four key players here, and it really depends on who you are. I would say, to anyone listening, I wouldn't go out and set up a crowdfunding platform, not yet anyway, because there's already this number of large, very well backed companies that are first to market, and they're going to have the market. So unless you are willing to put a lot of money and resources into it, I wouldn't do that. For the companies seeking capital, I think this 5 million target, and we have to go back to the word crowdfunding, the idea that if something hits a lucky streak in terms of, let's say, a social media algorithm can all of a sudden become the next big thing. We have to remember that there's a consumer almost. The investor is kind of considered a consumer. And so the 5 million cap is there to prevent, let's say, that spiraling way out of control. Okay. So we had the Elizabeth Holmes, saga, which culminated, I think, in her conviction in 2019, where she just got so much money on foot of information that probably wasn't accurate or correct. But so what I would say for both the companies who are trying to use this, that there's a cap, but if it's good, it will get traction. That's great. But for the investor, the small investor, and I think that's how we kind of started this particular part of the talk, is, well, you can be assured that if there was something untoward happening, it would be uncovered fairly quickly. So we're not talking about something that will, if it's a product that is on the market for 6 months, that means in 6 months no one has challenged its veracity or authenticity. We all want to avoid investing in a kind of a matchstick company where there is nothing there. So I would say for an investor, I'd always maybe set a minimum amount of time you want the offering to be up. And maybe have your own calculation. If it's €100 you're trying to invest, I'd spread it, of course, a diverse portfolio. But then also, this loan effectively, and we have to be very, very clear what it is as the investor you're buying. So it's a loan. Another word for a loan, and lawyers like to use, is a security maybe. You have a loan that is enforceable against a company. Now, if the company disappears, your ability to get that money back disappears. Okay. But what you're not doing is you're not buying shares in the company. So in terms of, let's say, priority, if the company, let's say, is liquidated at some point, you're kind of lower than a shareholder. And also we have to differentiate, and I think the regulation does a good job saying that it's not an ICO situation. You're not buying a voucher. If someone's trying to set up a hair salon, you're not buying vouchers to go in and get 6 months free of hair treatment. It's a loan. So, and it's the terms of that loan that maybe might make it either, if it's a certain percent interest, it might make it attractive, maybe slightly more competitive than what you would get in a normal savings bank. So they're the things I would look at. And what are the terms?
Let me ask you, because this really, really sort of hits close to home, as the Yanks put it. Like, it seems to me that we have two parallel systems running right now, and it's really fascinating because on the one hand we have this sort of adjudicated by the EU financial forces and regulators. We have this sort of like an official crowdfunding system that you just described that all the major crowdfunding platforms rely on. And then in parallel, as of late, we have what's called decentralized finance that heavily relies on formats like DAO and all kinds of Oracle protocols that are basically playing the role of financial intermediaries, something that the crypto space has long despised, but they realize that there's just no way to go anywhere with crowdfunding without intermediaries. So I'm wondering how these things can really coexist. This sort of people's way of crowdfunding using DeFi and DAO structure, and on the other hand, you have this official sort of officiated way of crowdfunding that's that deals in conventional fiat currency and stuff. But at some point, they have to either clash or to learn how to coexist and work together. I wonder if you have an opinion on that.
Well, again, looking back at what happens in data protection, the EU put out, a directive first, and it was kind of aspirational, but it got kind of the broad strokes right. And then I think, almost 30 years later, we had kind of the updated data protection regulation. So the regulation is just getting started. So that's the first thing. So it is, on the one hand, it's a free-for-all in terms of whoever can crack this nut, will be ahead, and then the regulation will follow. But I would say, and it's do you know what it is? It's almost, the whole thing is almost a contradiction in terms, because what we're looking at here on my screen is this vehicle for allowing small people to get involved, in investing, and then small companies having access to capital from multiple markets, and all of the EU being open game for everybody. Okay, so that sounds great. That's the aspiration. But then if you look at the top right in my diagram, the crowdfunding platform is like the bottleneck. And the reason why it's a bottleneck is because, for what you just described, the amount of red tape, they can have an index of projects. Great. Who's doing the background or running around of the money? I mean, I would have thought, let's say, the obvious course is, and I think I from what I gathered, this is an option in some of the projects, is that the payment goes straight to the company. And this is maybe this is the one that needs to be looked at a bit. So there is no intermediary. The crowdfunding platform will direct you to the company website, and you make a payment just like you're buying shoes. And the idea then is great, because you'll have loads of people doing that. If you ask the average person on the street, or you said, you put a gun to their head and you said, okay, I want you to buy, a percent of a Bitcoin in half an hour, go do it. They wouldn't be able to, because they can't really access, let's say, the wallet or set it up. So people, for this vehicle to work, that payment layer is missing. And like you said, at the minute, it's just the intermediaries are getting tied up in knots. So that's the one to look at. Which crowdfunding platform is going to crack the nut? And of course, the problem with that is you get into a whole area called conflict of interests, where you can't have a crowdfunding platform, the owners, having an interest in the companies. So that's almost a disincentive to some extent for them to find really, really successful companies. Is it?
It makes perfect sense. I was going to ask you about blanket regulation, because it sounds to me like we're headed in that direction, especially with the news from India. With earlier last week we got the news that India's preparing to ban crypto altogether, like China did, and Russia. Well, not Russia. Russia's a different story, but like China did. And then this week, the news comes in that it's not going to be a blanket blanket no, but it's going to be a 30% crypto tax. And simultaneously, they're going to release their own central bank issued coin. And I was wondering if the governments of the world actually have a perfect way to control this thing, whether it be crowdfunding or investing or just the flow of crypto, through ether. Just whatever you do on an exchange, whatever you do with fiat money or crypto or any other investment vehicle that you're using, they will always control an off-ramp when you want to convert it into a fiat money or use it in real life. They can always tell you, hey, from this day on, it's going to be 15% tax, and that's that. If you want to exchange your Bitcoin into pound sterling or euro or whatever, you're going to have to pay whatever you owe to the platform plus 15% crypto tax to the state. And you can trade, up to yin yang just until. So I'm wondering how this I don't want to call it danger because it's not danger. It's just the reality of financial movements in the market. But how has that come into the to this picture that you painted earlier with modern crowdfunding?
I'm trying to find the bit. If you bear with me
Sure.
for a second. Yeah. So I would just on that, I would direct people to Recital 10 in the regulation. Okay. So it's kind of vague. Okay. But if you do, and you can do a control function search for the word security in the regulation, I think it comes up 49 times. Okay. It's actually in the first recital that I mentioned earlier. This idea that, it's understood that people might invest and then wish to kind of trade on that position. That's perfectly fine, and that's built into it. But if we look at recital kind of 10, which is the next instance of that word being used, I'm just going to read it because I think, between you and me, Anton, we might understand a lot about the technology, but it's ultimately at the minute, in terms of how reliable it is can I do this, is the question. And right now, Recital 10 is like the starting point in terms of the EU. So anytime this question will come up, someone in the EU back office will look at Recital 10 and try and expand on it. So that would be, let's say, the next phase. Obviously, we have MIFID and all the other kind of directives and regulations, but for the purposes of how it ties into crowdfunding, I'm just going to read Recital 10. So it says, the provision of crowdfunding services aims to facilitate the funding of a project by raising capital from a large number of people who each contribute relatively small invested amounts through a publicly accessible internet-based information system. Crowdfunding services are opened to an unrestricted pool of investors who receive investment propositions at the same time and involve the raising of funds predominantly from natural persons, including those that are not high net worth individuals. The regulation should apply to crowdfunding services that consist of the joint provision of reception and transmission of client orders and the placement of transferable securities or admitted instruments for crowdfunding purposes without a firm commitment basis on a public platform that provides unrestricted access to inventors. So it's really that second sentence in Recital 10, which kind of sets it up. It says, maybe. That's the kind of the maybe part of it. But what it will look like, it will take another 5 years, because what they'll do is they'll say, where's the money? Who can we tax? And maybe who's losing out? And then kind of balance, let's say, investor rights, the first investors to get in, with, let's say, the smaller investors coming afterwards, and the company itself not losing out, because you don't want a position where, let's say, a loan that you provided on a certain basis is now worth 10 times the amount. So that's the kind of maybe the unethical element here. But the idea is that a crowdfunding service itself, okay, can itself be kind of crowdfunded. I'm not sure, and I'm not sure I'm reading that right, but that's very meta, isn't it? A crowd, you can raise funds yourself to become a crowdfunding platform.
I feel like I feel like we're just tumbling down the rabbit hole, and there's just no way out. I mean, we can go on like this for hours, and we'll just come out all crazy eyed and be not okay. Oh, you there? Okay, no big deal. Yeah, just
No, but
uh,
that's kind of the end
uh,
of my, let's say, rant and all that. So I'm happy to go back to freestyle
yeah,
land.
this is great because crowdfunding is something that I've been involved with for a few years now, and I've heard a lot of people say different things about it. I was involved in several different projects that try to crowdfund on several different platforms, and a lot of people came out very frustrated because some of the rules, some of the regulations, some of the just ways of doing business are sometimes borderline appalling, and I think it's a never-ending story.
Yeah.
The point is that regulators want to control the space as much as possible because they want to ensure that government continues to govern smoothly, and investors want to make as much money as possible in the shortest period of time as possible, and they want as little interference as possible as long as everything runs smoothly. Once something goes haywire, they run for cover, scream regulation, and that seems like a never ending, kind of like a magic circle that I have no idea how to break out of it. I don't think there's a way, to be perfectly honest with you. I think there's just predator capitalists will continue to make as much money off of us as they can, as long as regulators allow them. And when they stop allowing them, this will be the time when the big tech, we tried covering this yesterday, and other Amazons and Googles of the world will just run the Congresses of the world, to all kinds of forums of the world, screaming the freedom limitations, the hindering of innovation, and all kinds of crap they always come up with when people really try to get in their face and tell them that there's just no way that they can continue those practices. But anyway, so this could be a nice moment for us to sort of go into family practice, because
Yeah.
I'm thinking that it's like, for example, my wife and I will always fight on ideological grounds. And I'm sure there's a lot of people these days, especially, we sort of touched on that yesterday, but we didn't go too deep into that. I mean, due to, all kinds of confinement issues and pandemic and everything, people, not everybody, have huge houses and big apartments that they can really, coexist while not being together. But a lot of people just don't have that luxury, and I'm thinking that it sort of fills your plate right now, doesn't it?
Which?
Well, the fact that just people are, nowadays, they have to face each other more than they're used to. And when they do, they realize that there's just something, about each other that they can't stand. And what's the statistics of the breakups and split ups and divorces and where you practice? Can you sort of, do you observe any trends or anything on that? Or
Well, I can tell you that, let's say, in 2020, just in Dublin, there was over 2,500 applications made to the district court, which is the court that deals with issues arising from people who are not married. Okay, so 2,500, and then obviously you'd multiply that by, maybe Dublin is quite a highly populated area, so 2,500, let's say, out of a population of 1 million. You'll have to double that because there's two people involved, so 5,000 out of a population of 1 million, which is maybe relatively low. So in general, you would find that maybe people who aren't a good match figure that out before kids come along. So the problem, let's say, when the kind of litigation kind of rears its head, is where you have these people, they might have one, and you'd be surprised, lots of cases involve more than one child, and you think, oh my goodness, how did you end up having 3, 4 kids? I don't think I've come across one beyond 4. I'd say 3 is kind of the upper limit, maybe normal 2 or 3. Obviously, when it's one child, people are really possessive over the child. But just pausing that thought for a second, I thought what you said about, people talking is great. And, it's actually good, healthy to have arguments because everybody's different. And sometimes if you talk through it, my wife and I are doing what's called a marriage course at the minute. It's kind of, it's the same institution that does the Alpha course. It's kind of a church thing, but it's actually run in a secular way. But the idea is that we have strengths and weaknesses, and if we help each other enhance our strengths, then as a group, as a family, we'll do very, very well, and then our weaknesses will be minimized. So that's what should happen. Great. What happens when, and I'm just not being sexist, but just for the ease of this conversation, dad leaves, okay, and mum is left with, I'm just going to say, one child, and the child might be 5 years old, okay? So the child has had a period of 5 years where they see mum and dad living together, there's no issues, and then all of a sudden dad's gone, okay, and that's traumatic. I think they say that, if a child, even under 5 will grieve, even a 1-year-old or a 2-year-old will kind of mourn the if someone is not in their life, okay? So that's something that the child will have to go through, almost like a death. When you look at the supports people have when, a friend dies, we can all get counselling, but a child is in a very difficult position because they are there left with the parent who, they might have, trauma themselves from the breakup. And that's normal in any relationship. And I'd say certainly, I'm not a woman that has had a child and then had someone leave me, but I'm sure that's very, very difficult. So with all this kind of emotion rolling around, what often happens is mum, either unconsciously or consciously, and maybe sometimes a bit of both, sends a signal to the child, I have rejected your father. I want you to reject them as well. Okay? And and the tragedy of that is that kids are like sponges, they will soak it up. They know even before they can even say the word alienation, they kind of know what's going on. And the idea is then that their loyalty will shift with the custodial parent, okay? So that's kind of the setup. And then, the problem, and the problem looks like a lot of things, but, if you, this part of the conversation, Anton, I think we're going to go into freedom of speech and freedom of opinion and how what a can of worms that is. But I will start by saying, look, hopefully this platform and your viewers will have an idea that, in this conversation, we're seeking after nuance, okay? You might be listening to this in a car or maybe after the end of a long day. This is where nuance rears its head, okay? So you're not getting a soundbite from me. And I'm trying to challenge the soundbite, okay? And as a lawyer, that's what I'm trying to sell in a court. I'm trying to say, Judge, this is what needs to happen because X, Y, and Z. And I'm done in 30 seconds and my client wins. Well, unfortunately, in family law, nobody wins, okay? Yeah. So taking the whole area of rape and abuse, and particularly institutional abuse, okay? So in Ireland, we had a massive problem, as lots of countries around the world, with the Catholic Church and the cover-ups, okay? So we're in kind of we're dealing with that as the world is dealing with that, okay? So what we do now is we take very seriously anyone who alleges abuse, okay? And that's correct. I'm not challenging that whatsoever, okay? The problem is, though, if you are a mother of a 5-year-old and you want your husband just to be deleted from the life, your child, what you might do or be tempted to do is allege abuse. He abused me. And of course, not just physical, emotional. And now the idea is that emotional abuse is very, very, it's now regarded as just as serious as physical abuse, which is excellent, okay? But again, it's a very easy accusation to make, okay? Now, what I'm not doing here is I'm not trying to victim blame at all. I mean, like I said in the last talk, I did criminal defense work. And I know how hard it is for victims of rape and sexual assault to come to court to give their evidence. Okay, that's not what I'm talking about. I'm not talking about the practice of criminal law where society has rendered it necessary to prosecute that. That's not what I'm talking about. What I'm talking about is there will be genuine cases where a man has raped his partner, has physically and sexually abused the child. That happens. and then mum rightly takes on this kind of protective role to remove the child, and that's brilliant, okay? And then we have all sorts of women's refugees and charities that really empower women to leave and set women up with accommodation and help women kind of get up. That's excellent, okay? I'm not talking about those cases. I'm talking about the cases where the allegation is made for a sinister reason, for a reason that is not, let's say, justified. Not objectively justified, because of course if the man leaves, the woman will have, in her mind, a subjective reason for saying, this dude is bad news, I want him away from my son. So that's the context. And then when you go into a courtroom where it's not a history of law lesson, but rhyme back 100 years, the man is in charge, sorry, woman is gone, and that's it. And men used to lock women, clap women up in the nut house, as Daniel Day-Lewis said in the movie Lincoln. That was what happened. So years of the patriarchy, that is over. Women are now empowered, and there's a victim impact directive, which is excellent. Judges must listen if the accusation is made. But the problem is it's kind of treated like an on-off switch. A judge hears the word abuse, no access. See you later, okay? So my job is trying to navigate or trying to assist people who say, do you know what? This isn't, I genuinely have never abused anyone. This is made up, okay? And my job as a lawyer, obviously, historically lawyers have tried to explore that with their clients before they make the case. You do have to do a little bit of that because you're trying to make their case as believable as possible. So you'll tease some things out, okay? To get the reasons why this might be, and it's all the usual ones. She doesn't like me. She doesn't want the child to have anything to do in my life. Okay. But what you get then is the judge saying, I'm not qualified to do this psychological investigation, particularly in relation to a 5-year-old child. So I'm going to farm it out. I'm going to farm out this fact-finding objective to an expert. And this is where we have the whole industry of clinical experts trying to do this, okay? And like anything, if you can do 100 of these a week and spend 10 minutes on them, you might make, I don't know, $1,000 times 100. You could make $100,000, let's say, okay? And that's being very, very cynical, but the problem is humans are not, cookies. One size does not fit all. So you will have to do the job properly, you'll have to spend a lot of time at mum, a lot of time with dad. And probably you should maybe talk to the person who isn't living with the child first. So you kind of have their version and then you go in, because otherwise if you talk to the custodial mum first, no, everything's fine, little Johnny is fine, he doesn't want to see dad, he does not want to even know he's 5, and then they'll say, oh, but please, Johnny's a sensitive kid, so don't probe him on it. And you come up across these conflicts. Oh, hold on a second, he's 5 and he's ardent, he doesn't want to see his dad, but yet you don't want me to interview him. So you get into all of that, and really, it's a little bit like chaos theory, and the closer you look at a set of facts, the more complicated it becomes. So the Mandelbrot set is this mathematical object that is infinitely complex. So, and unfortunately, there's no court that can hear a month long of evidence, or the judges don't go and live with these people, the judges themselves. So it's very much secondhand. But really, I would say that all of this kind of experience with people, and if we ultimately with e-commerce, we will be talking about people. It's people trying to make a living, and people trying to, do their business, and people maybe trying to make a bit more money through vehicles. So there's a massive overlap between intellectual property and family law, because we're dealing with people at the end of the day. And then you just have the experience of the litigation, dealing with various experts, and then of course the litigation in court. And not sure I made this as clear in my last talk, is that I have of course been keeping up intellectual property law practice in terms of advising small SMEs on various discrete little points. So I have kept up my expertise, but I would say now, given the fact that I have kind of got this long period of high conflict litigation where, parents will fight to the death over kids, it's almost like a chemical thing. We're driven to be near our kids, and we will not stop. So that's kind of the it's almost potentially never ending. So So having that experience, I think, and I sometimes need a break from that to do intellectual property where it's less maybe emotional initially. Of course, someone cares somewhere. So that's it. They're my kind of dual focus. And I do work with an organization called parentalalienation.eu, which we can post maybe in the description.
Sure.
And I'm teaching that on a diploma in this. So what's the best way to get your say in, you know? And of course, we all have to be sensitive to single parents because it's a tough job. Being a parent is a tough job, but if you're a single parent, you're tough. So I'm in no way trying to say that all single parents are, you know, X, Y, and Z. That's not what I'm doing. I'm saying there's a problem in some cases, and my job is to bring clarity or to, you know, advance my client's position.
There's a lot to take in. I'm gonna when I edit the video, something tells me that I'm gonna review it several times. This monologue, because there's just so much to take in, and but one thing that I wanted to throw at you is like a practical case that sort of that presents that overlapping case that you just spoken about. I mean, that we have an SME, we have a husband and a wife, and we have two companies that are kind of subcontracting for each other. I'm talking about my boss and his wife, and my boss has got a company that I work for, and his wife, she and her company develops a mobile app for that for our business. So it's kind of a relationship, and of course they have kids. So it's a triple entendre relationship where they have to coexist and collaborate as and partners, husband and wife, and then they have to somehow make it as business partners, and then they meet at the dinner table as parents. So it's to my puny mind, it's almost impossible to comprehend how all that works. I can't even begin to imagine how, you know, how consenting adults deal with that kind of situation. If you have an input, I welcome it very much.
I mean, add to that, let's say, Donald Trump's experience, where on top of all of that, he was the president of America.
Well, he's got a lot of AIDS, but you know.
I mean, but still, what it was, and he said, you know, the big stack of paper. Look how well we're doing, handing it over. You know, I think we're, you know, some people are made for the time that they live in, and other people then just grow into it. And they obviously just didn't. It wasn't like none of that happened overnight, you know. And you know, myself and my wife are having this conversation. The minute he's going to be the breadwinner, he's going to spend more time with the kids. For me, I like to be around during the midweek with my kids as well. When they come home from school, that's kind of, you know. So I tweak things a little bit in that regard. But, you know, I mean, from the lawyer's point of view, it's, you know, when does that setup give rise to a potential conflict of interest and not getting anyone in trouble? I'm sure that everyone involved in both of those companies are aware that they're married. So that's the first thing. You would never conceal something like that. But where there's preferential treatment, you know, things like if there's an EGM or a board meeting on a specific thing, shall this company invest in this related third party? The spouse should remove themselves from the board meeting to allow an open discussion, because we have to remember that natural persons, even though they're very senior and might have the majority shareholding in the company, now company law is there to say that a company is a separate entity. And one must do what is in the best interest of the company. And if someone is kind of clouding that judgment, they need to not be removed permanently, but just saying, look, guys, this is it. I'm happy to go with the majority rule. I'm not going to participate in the conversation. And that kind of transparency hopefully will keep everyone happy, because otherwise you might get oppression. You might get, you know, an oppression action where, you know, a 2% or a 5% shareholder or a group of shareholders come in and say, hold on a second, you know, this isn't right because the company is losing out because there's this third party over here which provides the same service at half the price and so on. And that hopefully that type of issue would be solved in a kind of not necessarily in a courtroom, but in maybe where you get a mediator in, and the mediator spends a week listening to everybody and saying, look, this is really what should happen. And that just keeps costs down. So it's called the area of alternate dispute resolution, it's called.
Cool. Well, listen, hey, we've done an hour and this was really invigorating. So
Great.
Well, thank
Yeah.
you so much for
No,
your
thank you.
time and the fact that you went for this. This is great. I mean, I think this is a very valuable material that once we put it up on the internet, I don't think it's going to gather as much likes and views as Tommy Lee and Pamela's sex tape, but I'm sure there's a lot of people out there who'll be thrilled to hear this conversation. I don't want to call it a discussion because we haven't argued over anything. Mostly we're on the same page and everything. But yeah, thank you so much for doing this, Brendan. Thanks a lot.
Thanks a lot.
Let's keep in touch and hopefully we'll talk some more later on.
Cheers.
Appreciate it, brother.
Take it easy.
You
Bye.
got
Bye.
it. You got it.